A little loud. All right, thank you everyone for being here. I want to call this meeting to order for the City of Fate Planning and Zoning Commission meeting for August 20th, 2026. It is 6 p.m. And we're going to confirm a quorum. Mr. Director, can you confirm that we have a quorum?
Yes, sir.
Thank you, sir. One item that we want to discuss before we get started on the rest of the agenda items is item 5A, the public hearing for a zoning change request. Unfortunately, we have to have that meeting on September 17th. We have to renotice. So everyone will receive another paper notification about that upcoming meeting, which again is September 17th. For those of you that are here that wanted to hear about that item, if you still want to speak about that item at this meeting, you still can. We'll have a public hearing section to open the meeting. So you're more than welcome to stay in this crowded audience, but other than that, we will hear it again on September 17th. All right, and then the next item is public comment. It's an opportunity for the public to address the Planning and Zoning Commission on any matter, except public hearings that are included on the agenda. Comments related to public hearings will be heard when the specific hearing begins. Not seeing any speakers, anyone in the audience wishing to speak? Seeing no one, we can move into item 3, presentations. Item 3A, City Attorney, presentation on Planning and Zoning Commission role and procedures, sir. And rather than butcher your name, I'm going to allow you to introduce yourself.
Thank you very much. Mr. Chair, members, board members, my name is David Overcash, and I am the interim city attorney for the City of Fate, Texas. As such, I provide legal advice to the city staff and the city council primarily on behalf of all the citizens of Fate generally, the residents, inhabitants, etc. And then also serve this body as an extension of that. As you are an extension of the city council and of the city itself, I will provide legal guidance to you guys with respect to your performance of your official duties. And in conjunction with that, tonight I am here to give you a general overview presentation on the duties and roles of the Planning and Zoning Commission and what you guys need to do as board members, refreshers for some of you. Some of you may be hearing some of this stuff for the first time. I'm going to talk fast because I'm trying to be respectful of your time and the fact that you can read. So and also these materials are also going to be necessarily kind of surface level flyby overviews. There are half-hour versions of Open Meetings Act training and Public Information Act training available at the AG's website. You guys should have all seen those once already. If you haven't, you need to. You should go back and watch them again. If it's been a few years, those kinds of refreshers are great little overviews and are not too painful. They manage to make it somewhat digestible, and I think they're short enough that you shouldn't be bored to tears. So, without further ado, let's proceed through at least this presentation, if I can get the clicker to go. Oh, never mind, there's my problem. All right, so what we'll cover is the Planning and Zoning Commission's role in municipal government, what the charter, state law, and ordinance say about the duties of the commission. I'm going to talk about some of the big issues on Open Meetings Act and Public Information Acts, and then talk about ethics. So the P&Z role is your commission of the City of Fate, not an independent body. It's mandatory to exist in a home rule city. Some smaller cities, before they have charters, have the option of doing a planning and zoning commission, or they can just have their city council continue to perform that function. But once you're home rule, they say, look, we want the first look on these things to be by somebody that's not the elected officials and the politicians. Let's have them pick people who are members of their community, who they trust, to review and evaluate these things and give them recommendations and give them a better chance of being able to have more educated decisions on it. The commissioners themselves are appointed by the city council by a majority vote of its membership. So primarily the P&Z is an advisory body. You will hold public hearings and make recommendations. The recommendations include stuff on zoning district boundaries for the city council, the zoning regulations for the individual districts, recommendations on variances, SUPs, CUPs, anything that seeks relief from the zoning restrictions. And then you have some other ancillary duties relating to planning and zoning functions of the city, such as ministerial review of plats and participation in comprehensive plans and that sort of thing. So under the FATE charter, you have to have at least 5 members. Obviously, you have more. That's perfectly fine. That's the city council's call on how many they want to have, but the charter says that they wouldn't be allowed to do it with just 3. And then your removal with cause at any time by a majority vote. The only reason that I'm highlighting this is not intended to be a threat or anything like that, or to suggest that that's imminent for anybody, but I think it's important to remember that because you're appointed by a majority of the council and subject to removal, you're not really to be thinking of yourselves as an adversarial body or in competition with them. Sometimes you have people who, in good faith, think that they're trying to do the best for their community. They get appointed to a board, and then they think of themselves as having constituents that they need to argue with the city council about, right? And say that my constituency needs me to do this as a planning and zoning commissioner. Well, those constituents are really the city council members' constituents. And if you keep doing things like voting against things or making recommendations that disagree or challenging their view of the city, you can think with a reasonable level of certainty that they're going to vote to remove you and replace you with somebody who is going to do the job they want it to be done. So it's not that you're here to not contribute. Everybody wants your input. That's why you're here. We need your expertise, and we need you to give eyes on this and help communicate between and help educate the city council on the matters that come before them. But at the same time, your role is not to argue with them or be a competitive body.
Mr. Overcash, can I just add one point to that, please?
You may.
And also, just remember, we're giving our opinions as representatives of the community that the council has picked. We serve at their will. Just because the council votes in a way that is might be contradictory to a vote that we make does not mean that we've done anything wrong. It's not always going to be the same. They make votes for different reasons. We're supposed to give our opinion and vote in that sense. But to your point, not to be contradictory, but to give the best view of it that we can as representatives of the community. So don't be alarmed if we all vote to approve something 7-0 and then it gets denied at council. It happens, and it will happen.
And I think that's a very important point to make. It's not that we need uniformity of thought. This is not supposed to be something where you guys are not allowed to have difference of opinion or to have different perspectives on things, particularly when you're talking about discretionary issues like zoning and variances, which that's important. That means exercises of individual judgment, and people are going to weigh things differently. And all of you also have different backgrounds and experiences that you'll be bringing to the table to share and that shape your perspectives on the matters that come before you. And they may be different. And some times you'll have a unanimous vote at one level that gets rejected unanimously at the level above, or you'll have a split decision at the lower level that then they say, well, we don't care about any of that, it's unanimous up here. That doesn't mean that people are trying to pass judgment on the work that you've done. It's just that the calculus came out differently. So you're required to serve staggered 2-year terms, but often members are reappointed continuously, so the staggering doesn't necessarily mean much until people start vacating seats. And your actions have to have affirmative vote of the members present, a majority of them. So if you have too many abstentions, those count as no votes, and so things can fail if people are declining to participate in the votes. Under law, the city council cannot act on zoning districting or regulations until it has a report from y'all. That's one of the things that state law requires you to make a recommendation. Whether it's up or down, yes or no, you have to say something before they can act. You're going to be you're charged with reviewing current and proposed ordinances to make recommendations to the council. Somebody wants a zoning change, you're going to review that. Somebody says, I don't like the zoning I'm in now, and makes a proposal to change it. You would potentially review that and make recommendations to council. You review amendments to the comp plan, review plats, zoning requests, and make recommendations to the council for the zoning requests. Plats, you'll be doing approvals of some of them, and we're expecting that to change somewhat for a short period of time soon. You're required to keep records. Appear in person to the city council. One of the members of this body is charged with showing up in person bodily when the city council asks. I'm not sure why that's there, but it's there. I don't know who the person has to be. I don't think that's necessarily determined, but theoretically it would be a problem if all of you refuse to. And then you can be given a lot of other duties. You can be given almost anything else. So you look to the ordinances of the city, the charter, to see what else have they asked you to do. So getting into the duties individually, zoning is one of the biggest ones, and it's just the term for describing the sets of regulations that you put on land parcels, generally by regions. Zoning districts are the various flavors of classifications, the recipes of various regulations put together to give different styles of development, commercial, industrial, et cetera. They've been around for a really, really long time, not forever. So there's one city in Texas that famously does not have them, and that's Houston. It doesn't have zoning, and if you've ever wondered why Houston is the way Houston is, the lack of zoning has a lot to do with why it grew up to be the particular animal it is today. You're supposed to evaluate these zoning regulations and proposals for changes, make recommendations, and then, those regulations include a variety of things relating to how land is used, minimum lot sizes and stuff like that, that also can have an impact on platting and subdivision rules later on. The types of things that can be regulated by zoning are detailed here. You're probably familiar with them when you've reviewed the zoning classifications in our ordinances. And these are the main parameters that the city uses to control the style development and the general look and feel of the whole city, and in particular the population density, and execute on the comprehensive plan. So this is discretionary. The city council is not required to zone. The city begins entirely without zoning. When the city was first incorporated as a Type A general law city, there was no zoning anywhere. And but this is something that they can do, and the overwhelming majority of Texas cities do it on the regular basis for almost all of their territory. In their territorial limits, their annexed land. And as you can see, the purpose of it is quite broad. Texas law says that there's a whole lot of valid reasons for this, and this is what you're thinking about when and these are the kinds of things you should be thinking about when you're trying to make decisions on zoning, is that you're doing it for the purpose of promoting public health, safety, morals, and general welfare, and preserving places of historical, cultural, or architectural importance and significance. So that is the state law charged to what zoning is supposed to be. That is the purpose of zoning. Now, how do we do those things, and what are some of the other components of it? Well, as dictated here, these are some of the things that we're trying to prevent, right? It's more about talking about regulating traffic flows to lessen congestion, secure safety from fire, panic, and other things. That's what we're all trying to do. Now, the last sentence at the bottom I put in all caps because it's something that's often overlooked. Zoning, I will say, is something that happens to you. It is not something that happens for you. The government, the city council has the power in Texas to dictate what the zoning regulations are over the land and the territory, unless and until the charter is amended to take that away or state law changes. Now, by and large, almost all elected officials prefer to give zoning to people based on what that person wants, right? On what the landowners want. But it's hard to find unanimity in all those things, especially when you're talking about larger parcels of land. So there are two things that are prohibited in the United States when it comes to zoning generally for a variety of reasons, and that need to be concerned sometimes when you're doing really small annexations, is that you cannot do spot zoning. You're not supposed to be isolating small properties and treating them differently than everything around them. And when you zone things in too small of an area and too tiny of a piece, you run the risk of having that situation arise, because it'll be harder to keep it uniform with its neighbors or make it make sense in a neighborhood. That's part of what the comprehensive plan is intended to do. And the future land use plan is to draw larger areas and say these are supposed to be alike each other. And so we're going to try to make sure that when zoning comes into these areas, it's all going to be of compatible character, even if each adjacent lot is not necessarily having exactly the same zoning. So you're trying to help make that coherent through the different categories of zoning groups that you lay out in the comprehensive plan. But you're not supposed to, even though often zoning cases come to you one piece of property at a time, you're supposed to be avoiding spot zoning. We'll deal with that and try to flag it out to you if it's going to be a problem. If we think that this is going to be an issue, this will not sneak up on you. We're not relying on you to watchdog that particular thing. I just bring it up to mention to you in the context of why can't we do certain things? Well, there's certain, what can't we do? Well, that's one of the things that you can't do. You also can't do contract zoning. You can't promise people in advance that the members of the city council will vote a certain way through executing a contract. You can't have a development deal that promises the developer will get a zoning classification sometime in the future. They have to do their zoning and then sign their contracts, okay? We can't do things where they're bribing us or we're bribing them to accept or do certain types of zoning materials, or zoning classifications. So there are often very ornate steps taken to try to arrange for this and to get zoning done in advance before you have to get to that step. And then sometimes you're taking development agreements and there's clauses in there that say everybody's got their fingers crossed that the zoning is going to work out the way it is, because if the zoning doesn't work out, this whole deal collapses. So that's often the way that you have to do it. It's not that the cart will always be before the horse or the other way around. Sometimes they will come in different orders, but in order to make sure that doesn't run afoul of the law, we'll have to make sure that there's an escape hatch, essentially, because we can't pre-commit the vote of the city council. So zoning both enables and restricts land use. You've already got zoning in Fate, so that ship has sailed. You're not going to just be able to wave your hand and get rid of it. And all newly annexed property defaults to ag zoning. All right, you are allowed to, when you annex something, zone it immediately, but you're not required to. So in many cases, a annexation might occur, or a bulk of territory or a big block of territory might have been added to the city limits. Nobody knew what they wanted to do at that time with it, or there weren't any plans for anybody to change what they're doing. It was all ag land to begin with, so they just leave it ag. That's kind of the default zoning. There's some unusual consequences of that, though, because we've got some fairly or really old sections of town here in Fate that are still under ag zoning from the original donation days. I mean, when it was just kind of, they've never, ever once been zoned, so they're just under the default classification and have been for the entire time. Sure. I'm sorry, what is the?
Like the AG zoning, is that something that identifies that we don't make?
Natasha, can you make sure you turn on your microphone? Thank you.
Oh, I was just saying, for the ag zoning, is this something that someone watches to make sure we don't do anything wrong regarding voting?
Well,
This
okay, so
particular?
you can create ag zoning. There,
Yeah.
people can ask for it. If somebody had a property that had already been zoned commercial or something like that, they could theoretically regress into what is, kind of the raw state. The raw land zoning by default is ag. You're almost never going to be asked to zone anything to ag because it is, like I said, the default when property is added in. There's no reason that you need to preserve it in special thing. There's not really any special rules that are specific to the ag zoning, other than it's just before the council picks something, it's ag. That's the most significant thing and the main reason I'm bringing it up here.
Mr. Overcash, if I can add just one item to that. I think one of the things, there's not really doing anything wrong. The thing to keep in mind is that we may have a zoning change request that comes before us to change from ag to something else. And we will ask the question, well, has this always been ag? It was annexed as ag. It was never, there was not an intentional classification as ag. So we have to keep that into consideration and then look at the future land use map and see what their plans were for that section. It wasn't that it was intended to be ag, it's just a default setting.
Yes.
And in some cases, for example, you might have a land out on the outskirts of town that gets annexed that might have a scrapyard or a car repair business or something like that established on it. It would be zoned ag even if that activity was not appropriate for what was already in place when it got annexed, because you don't bulldoze it and kick them out when you annex it. That's not what's involved with annexation. It's just coming to the city. But they would be under ag zoning, at least until some further action was taken by the council to put different zoning on it. So the land use table delineates what the three types of things that you can use land for, the three different categories for each use. They're either allowed by right, expressly permitted, allowable in the district if and only if they have a specific use permit, which gets approved by the city council. You guys will review those first and make a recommendation, but it has to pass the city council as well, because the specific use permit embodies an amendment to the zoning ordinance. It is an amendment to the zoning ordinance that is just happening on a one property basis, on whichever parcel or parcels of land that specific use permit applies to. Essentially, they have a special, unique snowflake zoning ordinance that's just for them. It's almost like the planned development district zonings and stuff like that that come across sometimes that are special purpose built for larger developments, where you're trying to do some mixed or unique tuning of regulations that isn't available in your current array of zoning districts. So the SUP is doing that on a single parcel basis, and the planned development would be kind of doing your custom zoning on a larger scale basis. But they're both zoning ordinances. And then, of course, the land use table tells you what you can never do in that district. So when you start out as ag, there's a bunch of stuff that you're never allowed to do according to our zoning rules. And if you want to start doing that and you weren't doing it before you were annexed, that's why you need a zoning change. So you would need new zoning in order to be enabled to do more things. Now, whichever zoning classification you pick is going to have restrictions that come along with it. There's going to be some things that are not allowed in that zone, just like in ag, you could do certain things as of right. Nobody could stop you if you wanted to start doing those things new. So it's both enabling, because it enables you to change to a classification that has different options than the one you have now, and of course it's restrictive because all of them have restrictions. So there's a relationship between zoning and the comp plan, as I mentioned before. The zoning is a critical part of implementing the comprehensive plan, and what we see here is a picture of the future land use plan, which, as you can see, is color-coded, and the city looks like a quilt, but ideally, you're looking to have lots of stuff that's the same color in blocks together, right? That's how you avoid having spot zoning problems and stuff like that, and a weird disjointed feel to your city, and lots of problems with incompatible uses rubbing up next to each other. So the various zones of the comprehensive plan represent acceptable categories of individual zoning districts beneath them, and just generally the look and feel and density projections and intentions that coordinate with the thoroughfare plan and with your water and sewer plan and all of your other utilities and stuff like that. So this is how you help make it into cohesive policy. So this is particularly important because zoning is required to be consistent with the comp plan. You're not supposed to be approving things that would contradict that map. If somebody asked for something that is not allowed in the yellow zone, you're supposed to say no. That's one of the things where discretion only goes so far. The discretion is not to deviate from the comp plan, okay? The discretion is to how do we operate within it, okay? How much do we let people operate within the guardrails? And sometimes you're gonna say it may be allowable here, but I don't think it works and I don't want to allow it, so I'm gonna vote no. That's perfectly acceptable, all right? But of course, you can't just vote to approve things that have no business being there because the city council has already told you that in the comp plan. Again, this is another kind of way that the hierarchy represents itself here, is that, you know, the city council, while you will have helped, or previous P&Zs, as the case may be, helped formulate the comp plan that's currently in place here today. It's ultimately the city council's comp plan, and they're needing you to execute it. They voted on it that way, and so they need you to behave accordingly. One of the other major duties is involving platting and the subdivisions of land. So that's how you divide big parcels into smaller parcels. The entire state of Texas started out as one big chunk, right? And it was owned by the state of Texas. And then all land has then been passed down through a succession of deeds, right? And those are recorded in county courthouses, and those deeds and conveyance tell who sells the land to who, but what pieces they're trading back and forth is generally defined by the plats. All right, you convey land by a parcel. The parcel is going to be defined by its metes and bounds set forth on a plat instrument. So here's an example. This one is, I believe, part of your old downtown donation. I think it may be familiar to you. So this is what lays out the public roads, a lot of the improvements. You'll see the easements on there and that sort of thing. So this is what will be recorded at the county in order to make sure that the world knows how land is set up there, where they can buy things, what they can buy, and that sort of stuff.
And I will say that the plats that you'll see look very different from that one. That one's
yes.
handwritten and illegible. The new ones are much easier to
Yeah,
decipher.
this is actually the best copy, I think, of this one I've ever seen. I've seen this one a couple times, and it's been in worse shape. These things, you know, they started out as often oversized giant pieces of paper that, especially the ones from, you know, back in the railroad days and whatnot, that you're seeing some of this stuff here. And so over time, they got photocopied. They had to be cut sometimes into pieces so they could be stored in different filing cabinets and whatnot. They degrade over time. There's a fire at the courthouse, you know, a succession of things over time, and they can get really nasty and hard to decipher. Thankfully now, most of them will have all the text on it typewritten and that sort of thing. So yes, they will be indeed much better and easier to process and read documents. These ones also have great features like I've seen some of them where, you know, the world just ends on the edge of these things. There's no clear end to the map. Sometimes it's more of a here there be dragons kind of thing where it's like, who knows what's going on there? We're not going to label who owns that land or what it is or anything like that. It could be anything. So anyway, the plats will come before you when somebody has a larger parcel of land and they want to turn it into small pieces, one of those city blocks into 4 lots, or, you know, in theory, an area that is multiple city blocks and lay out the streets and that sort of thing. Also, potentially a plat could combine lots. You could be destroying the smaller pieces of property and building a bigger aggregate thing. So you would be doing this potentially in the extraterritorial jurisdiction, the ETJ, as well as the territorial limits. And so if somebody wants to divide property, they have to do a plat. And because this is required for them to do their thing and to be able to have land and buy and sell it, that results in this entire scheme being what they call a ministerial duty. And we'll come back to that in a minute. But the plat itself needs to describe the property with certainty, describe it by metes and bounds, make sure it closes, that sort of thing. Needs to locate the subdivision properly, depict the streets, alleys, and parks and public dedications, meaning easements. All right, that's always one of the important things that you want there to be depicted on the easement, on the plats, is all the easements. So if there are new ones that you know where they are, and honestly, you want them to depict all the old ones too. If it's been around for a long time and the easements were created by separate instruments prior to the platting, you want them to go find all of them because you want the most up-to-date version of what's going on there. So, because it makes it the easiest way for people to find out where they can put utilities, for example. And then, of course, they have to be signed by their owners. So plats are under a shot clock. You're going to hear this term every now and then, or you might. It is a change to Texas law that happened in 2019 that rocked the world for planning and zoning commissions everywhere. I'm sure you felt the rumblings, even if you weren't appointed to this body yet. It wasn't that big a deal. But it has changed things dramatically in the sense that we now have deadlines that were very, very firm. There were some cities that were evidently getting everybody really mad because they would kick the can down the road and come up with interminable delays and just refuse to approve things in order to stall projects they don't like or didn't like. And so the Texas legislature was convinced that they needed to take action. And so they said, we're done with this. We're going to say you have a deadline. And if you don't meet the deadline, it's going to be automatically approved. So that's the thing. If you do not meet the deadline of the shot clock, they get to do what they want. And you can't, and the city would have very little ability to stop them. And so that means that you have to make a decision on plats to approve, disapprove, or approve with conditions. Those are the three types of decisions you can make within 30 days of its filing, or it ends up being automatically approved, and then they have a 15-day secondary shot clock that runs in terms of they have a deadline to fix it with their resubmittal. Now, if you do a denial or a conditional disapproval, it will be necessary for us to articulate a list of reasons, right? If a conditional approval, well, what are the conditions, all right? You should know those before you walk out of the meeting to some degree, right? The conditions of disapproval also will need to be stated with certainty if that's what we're going to do. That's particularly important because you make a list of what's wrong and why you couldn't approve it, and that's your list. Once they fix items 1 through 4, because you gave them 1 through 4, they get approved. You don't get to come back and say, oh, wait, we forgot about number 5 and number 6 and number 12. Nope, ship sailed, all right? So it's got to be a comprehensive thing. You don't just stop and say, well, we deny it because we found one problem. Find all the problems, because if you're going to deny it or conditionally approve it, you got to list them all, or you'll end up having to live with those errors lasting as a legacy.
And David, if I can add, just in case you guys are starting to get nervous, that's our job primarily. We're the ones that do the in-depth technical review. We'll bring our recommendation, and if we identify deficiencies, A, we probably will have tried to work with the developer to fix those before it comes to you. Or B, if they remain as conditions, we'll identify those and share that with you when you see it. Plats tend to be on the consent agenda with P&Z and council, so it's not something that has a discussion. It's always available for discussion if that's the prerogative of either body. But again, I just want you guys to don't think you have to sit there and pore over a plat that you're unfamiliar with for a couple hours. That's what we do, and you're just kind of making sure we're doing our job in reviewing it.
Indeed, that is going to be something we'll get to soon when we get down to the forms of the motions that you guys are going to use sometimes. There's going to be a lot of, with the conditions in the staff report. That is often the most elegant way to get complicated things done. I was hinting at this a moment ago. There's a critical distinction between the standards of review for your two primary functions when it comes to subdivision of land, platting, and the zoning and variance SUP processes. Duty is discretionary if you get discretion to make decisions. You're allowed to consider different factors. You're not all required to apply the same grading rubric or set of priorities to something. You can have your own feelings and priorities and say that I like it, I don't like it, based on things. The other people can't yuck your yums, would be one way to say it, in terms of discretionary, exercise of discretionary duty. Now, if it's ministerial, and plat applications are the one I'm going to keep coming back to as the best example of this and the most important one. If it's a ministerial duty, there is not an exercise of discretion. You are asked to perform like a robot. This is the kind of more primitive robots, even more primitive than AI, because you're not even expected to talk in complete sentences kind of thing. All right, it is just hold the application up next to the law, and unless it conflicts with the law, it must be approved. It is not a decision about whether or not you like the development. It's not a question of whether or not you think it's a pretty picture. It's not a question of whether or not you want there to be another car dealership or you want there to be something else there. It is not about the desirability of the land use or what this person wants to do. It's not about whether or not you think as soon as you approve this, they're going to sell the land to somebody who's got nefarious plans. That's not your job. That is not what the role is. It is a ministerial review of does the paperwork meet the standards set out in the subdivision codes. If it does, it must be approved. And that is something that you may get static for from time to time when, and some people from members of the public don't like that. They watch all these plat approvals being unanimous all the time. They're like, why is the P&Z unanimous on every plat approval? Why is this happening? Why aren't anybody speaking up and fighting some of this development that we don't like? Well, it's because plat approval is not where you fight it. Plat approval is not something that they are supposed to be having discretion to vote against. It's You're just grading a paper, but it's not an essay. You're grading like a bubble exam, okay? That's kind of the way it works out. So there shouldn't really be much subjectivity to it. And then if you're going to deny something when you're doing when you're doing the plat approvals, you have to identify why you're doing it. So if you're going to deny something, you have to be expected to back up your denial and explain why you did it. Now, the staff report may give a list of 10 good reasons for you. So if it's recommending denial, obviously rely on it. But, you know, if you are contradicting the staff report, or if you're saying, well, I don't care about these conditions, I just want to vote to deny, you may have to explain that in a different way. So it just has to conform to the general plan of the municipality and its current land and future streets, the infrastructure plans, and it can't create messed up lots, you know, or new setback violations. You know, that's what you're talking about. Does it recognize all the easements? Did it leave out the easements? Is it trying to destroy them? Are the streets in the right place? Is it making new streets in the wrong place? That's the sort of stuff that you would be potentially able to deny a plat over or impose conditions about. So, P&Z duties. You have meetings. You've got a president, chair, or presiding officer who runs the meeting, decides the order of operations within your agenda, recognizes speakers as having the floor, and is responsible for maintaining order. Also generally calls for the motions and votes. We follow rules of procedure in here. Generally, it's referred to as parliamentary procedure, even though this is not strictly a parliamentary body, but we would be generally following Robert's Rules of Order. I believe that you've adopted those through your bylaws, at least by reference. The chair should be informing speakers of rules, including time limits, and help prevent interruptions of speakers on the floor. We're subject to the Open Meetings Act. So that's important to know when we're talking about meetings. You have open meetings, which are open to the public, and you have portions of your meetings, which will be closed meetings, which is generally going to be only for legal consultations or something like that for the Planning and Zoning Commission. You really don't have very many other causes to go into closed session. But the way that would work is we'd have an open meeting. We'd have a posted agenda with an open meeting listing. There'd be agenda items listed on it. There would also be a closed session listed. You would come out, you would do whatever business you wanted to do in the public eye in open session. You would announce a time that you were going to then recess into executive session, go back and get your legal advice, then come back out, come back into open session, maybe take more action, maybe not, adjourn the meeting. But that's how that would work. It would not be an isolated event on a standalone thing where the only thing that happened was the backroom meeting. On agendas, that's one of the most important things. The agendas define what you can do and cannot do to some things. So they also limit what you can discuss. All right, you guys are not supposed to be deliberating on items that are not on your agenda, which means that you're not supposed to have conversations about city business and members that are larger than a quorum unless you're at a posted meeting. You can proceed through, the presiding officer, though, can proceed through the P&Z business in any order he really wants on the agenda, except that you should not take any votes until you've given the public an opportunity to have the general public comment period. That general cattle call thing that you had tonight and had no speakers, no takers on. They're going to be relatively frequent where you have no takers on that, because often when people come to this body, they're here for a specific item, and they might be here for the public hearing on that. But they're allowed to discuss any topic they choose, not just agenda items. I mean, you post on your agendas, and it's generally been the style of your presiding officers to say, hey, if you're wanting to talk on a particular public hearing item, well, why don't we save that for that public hearing so that maybe people who want to leave before that happens, you know, don't have to wait as long. But ultimately, the public comment period is not limited to the agenda itself. They can talk about anything, because part of what they're supposed to be able to do is address you all as a body to maybe get something on a future agenda. So that's one of the primary reasons why you got to let them do that. If they have a public hearing, the chair has to open a public hearing, announce the time, invite all interested speakers at the public hearing to speak, wait until all they're done, then close the hearing, and then you can take a vote. So other than those two limitations on the fact that you need to front load the public comment even before you do consent agenda and stuff like that, and the fact that you have to do public hearings before voting on those individual items, otherwise you can jump around agendas.
David, because the question has been risen to me a couple times, and I don't recall it being further on in the presentation, can you just describe what a quorum is and what that number is and how people can discern whether they're reaching a quorum if they're discussing something that's off the agenda?
So you've got 7 appointed members on this board fully when you're.
Currently 6 occupied, but 7 total.
Yeah, okay. Yeah, that's what I thought. I thought you had a vacant seat. I know that I can see literally an empty chair,
Yeah.
but there's not a blank tent card next to it that says vacancy or something like that. So with a 7-member body, a quorum is formed by one more than, just enough to get a majority. So in your case, it would be 4 members of the body can serve as a quorum. So that is the minimum number of members that have to appear at a meeting place in person in order to conduct a meeting. You have to cancel them if you have less than 4 people who are able to attend any given meeting. Also, when we get to the idea of you got to restrict your conversations about city business outside of open meetings, that's important because a group of 4 or more of you is a violation of the Open Meetings Act for you to be discussing city business, P&Z business at least in particular, outside of a posted meeting environment. And the properly posted meeting in terms of having that item on the agenda. Now, this is going to be raising questions with everybody because social media exists and Texas law doesn't accommodate for it yet, okay? The Open Meetings Act was written 30 plus years ago and there wasn't an internet to worry about and they really haven't really gotten all the way through. The legislature has a low priority on this because while they're subject to the same rule, it's a lot bigger quorum, right? They have a hard time getting to a quorum by accident, right? Because there's hundreds of them when it comes to the representatives. So they are a lot less concerned about how easy it is for a group of 4 people who are in a relatively small community as a growing city like Fate to find each other and be on the same message thread on social media. I cannot tell you that there is a whole lot of safe territory there or anything. I just urge you to be cautious and at the very least refrain from commenting yourself more than anything else. Read it all you want, okay? I certainly, there's no limit to you receiving information imposed by the Open Meetings Act. Exchanging it between yourselves, that's really the problem. Telling each other what you think, all right, that's deliberating. In talking about how you plan to vote, that's the problem, all right? That's what the Open Meetings Act is trying to prevent when they say we don't want you talking about that stuff or deliberating outside of open meetings. But listening, receiving information so that then you can come to a meeting and say, this is what I heard from the community, this is the feedback I got, this is the stuff that I was talking to my neighbors about, all that sort of stuff is great.
Mr. Overcash, and one thing for commissioners, the times that we're going to be most subject to this is going to be right before and right after meetings, especially right after meetings. We might have heard a contentious item where there was a lot of discussion, a lot of public speakers, and we had to vote on it, and then our meeting ends, and we all want to talk about it. So we just got to be very careful because talking in those moments right immediately before and immediately after meetings is probably going to be the most opportune time for us to violate quorum.
So what would be your suggestion of how can we discuss it before we go and vote for the item? What is the proper way?
Well, there is a certain amount of limited communications that would be safe to have as long as you were only talking to 1 or 2 members. You can talk about items in advance outside of meetings, but the problem is if that one person then talks to 1 or 2 more, you can end up building what's called a walking quorum.
Yeah.
And I'm going to get back to that, but honestly, I gotta say, the best way to do it is to not discuss it outside of the meeting. Save it for your meeting. That's what the meeting's for, is for you to have your discussions about the items in the business before you. That's my best recommendation. Now, you can ask staff all sorts of questions and potentially get all sorts of information back from staff to educate yourself about the item, right? To refine your own thinking about it and be more prepared for your debate and discussions. But you shouldn't be doing that with each other, because you're going to be running a risk of, you're going to be just ever increasing risks of Open Meetings Act violations. So I'm not saying that you can't do it or it's impossible. I'm saying it's never safe, and I'm the lawyer. So I have to say, risk averse, avoid doing it. I recommend to city councils that none of them use social media.
And real quick, if you do have questions about an item that we're going to be hearing, I would recommend emailing city staff with those specific questions. They can respond with answers. And also, if they feel it's appropriate, they can share that information, that question and answer with us when we all get into the meeting, and we can all hear it at the meeting at that time. But there's definitely not a limitation on you asking city staff questions before we actually hear the item. Especially important if you might catch something that you have a question about that actually should have been noticed or should have been in the documentation. So you might actually catch an error, or you're just getting information, but definitely better to be prepared.
Okay.
And I'll say that by and large, the overwhelming practice is when the city staff gets questions from y'all, particularly if multiple of you have questions. They will kind of put those together in a FAQ or kind of a one-stop condensed memo of, hey, y'all asked some questions. Here's what I can tell you more information about. And bleh, everybody will see the answers to each other's questions kind of simultaneously, okay? We can do stuff like that in that way that avoids it being a deliberation between y'all where you're improperly meeting. Now, we have to be careful about how we do that in order to not turn ourselves into the conduits for the Open Meetings Act violations too. So sometimes we're gonna say, we can't answer that yet, we'll have to wait until the meeting. You know, sometimes that's gonna be the way it's gonna go. It's like, that's a great question, we'll address that later, okay? And we're just gonna have to ask that you be patient on that. So back to the overview of some of the P&Z duties. You know, I said that, you know, here's just the kind of layout that you'll commonly see on the public hearings. The presiding officer is responsible for the control of the floor. The idea is that if you want to be formal about it, you have a presiding officer who formally recognizes everybody and calls on them before letting them speak. Obviously, informality is perfectly acceptable as well. This is obviously a lot to do with the style and tenor and the amount of people in the audience on how much exercise and control it needs to be. Just general principles are that, well, as with any rule of politeness from back in kindergartens, take turns, you know, give everybody a turn before people start taking seconds, that kind of thing. Is make sure that you try to let all of your fellow commissioners speak their voice before you keep wanting to jump in and control a conversation even when you're passionate. Now, during a public hearing, anybody can speak from the floor, but you know, it's going to be for a limited time. They don't get just all the open mic night time that they want. You should always favor hearing comments rather than shutting people down or telling them they aren't allowed to speak or it's not the right time. I would say that by and large, you should do that, allow that. However, if they had a chance at the public hearing and decided not to get up and speak during that, you don't need to necessarily indulge them yelling at you from the back when you're actually getting ready to vote, okay? You know, or arguing with you when they hear something they don't like way later in the meeting. The chair is allowed to extend the time for a public comment to happen. It's common practice for people to ask speakers at city meetings to state their name and address and stuff like that. I will say that while that is by far and large the most common practice, it's not required. So just, I would say one thing is don't let somebody get weird and say that, you know, you can't speak unless you'll tell everybody in the world your address, because the rule that is not a rule. That is not a rule. The main reason that most cities do it, though, is so that the staff can make outreach and get in contact with that speaker afterward if they storm out of the meeting immediately after they're done talking at the microphone, which happens sometimes, and also just to help give context to their commentary for the benefit of everybody, because knowing where that person lives in town will help orient you to where their perspective's coming from. Why are they, when they say talking about their neighborhood, what neighborhood are they talking about, right? And so that's one of the main reasons you would ask people to disclose that information. But you know, sometimes you'll have developers come up and talk to you and they'll be, my address is Florida, you know, it's gonna be, I don't live here, you know, and that doesn't mean that they don't get to address the body. So how do you do something when you're on the P&Z if the P&Z wants to do something or you as a member want to do something? Well, you take actions through motions because we're doing that parliamentary procedure thing. So it's a proposal to do something, and if a majority approves, and they can either be simple or complicated. You can have, if you have a motion from a member that's been recognized to have the floor, or at least the chair chooses to recognize the motion, if he thinks that could be contentious. If it gets a second, you should put it to a vote, right? You know, it doesn't necessarily have to be that a consensus exists before you vote on something. Nope, it only takes 2 people to make y'all vote, but obviously it takes more than 2 of y'all to win. So there's different ways of doing it. Some formally, under Robert's rules and most other versions of parliamentary procedure, the motion and the second to come, and then you debate it. And then you discuss what everybody thinks about it. Somebody proposes that you approve it, then you argue about whether or not you approve it, then you vote on whether or not to approve it. But by and large, most people just don't like doing it that way for whatever reason. They say, no, let's talk about it first and then figure out what the motion is going to be. And so that tends to be the practice in most cities and at most of their boards and commissions. I'll say, you know, people do it the other way, but it'll be more common, and I expect that y'all will do what most people do, which is you have as much discussion as you can and then let that discussion inspire somebody to make the motion.
And real quick, Mr. Overcash, for everyone on the commission, the way I like to handle items that we hear, we get staff presentation, we have the applicant presentation, we have public input, public comment, and then we have Q&A at that point. And most of the time through that Q&A, we're also able to address some of the public comments that happen because we're not going to interact directly with the public speaker. But I want everyone to know that at any time, you're allowed to make a motion. I don't have to necessarily call for a motion. If you want to make a motion and you ask to speak, you have the floor, you can make a motion at that time. And if someone seconds it, we can act on it at that point, call for further debate, and then take a vote. So just want you to know, yes, we will call for a motion at some point if we don't have one. But if you want to make one before, then you're more than welcome to.
Motions can sometimes be interrupted by other motions. I am not going to get into any charts or anything like that or any of that. Please don't make me. I know it. I know a lot of it. I kind of like it, but I also hate it. I do not want to be your parliamentarian, and honestly, most of the time I wouldn't be. For the P&Z, I could act in that role because it's less complicated than when I do it for the city, than when I'm at a city council meeting. For them, I really don't like to be the parliamentarian because I don't want it to look like I'm picking sides between 2 people who are obviously arguing about something, or they wouldn't be asking the parliamentarian a question. So, in any event, you can study those on your own time if you are wanting to get complicated about that. Here are some sample motions that you might find handy for future reference, and hopefully we'll see a lot of these be able to come true. I move that Plat 1, 2, 3, 4 be approved as presented. That would be a motion that's appropriate when something is right. It's good. The staff report says it doesn't need any changes. It can be approved as is. Everything is hunky-dory. That's one of the favorites. Hopefully, you'll be able to do that a lot because staff put so much work into pre-screening this stuff before it gets to your agenda, okay? We really don't want contentious items to come to this board all the time. We don't want you to have to make hard decisions and vote things down. We want you to make easy decisions to approve. So we try to get you to yes before it gets to the agenda. We're trying to say this should be as easy as possible. You also have the version of approve it subject to the conditions listed in the staff report. That's another good one. There may be 2 or 3 conditions. Oh, they have to move this thing. They got to observe the 35-foot setback. We want to make sure there's a condition that says that they won't put a driveway closer than this close to the intersection, something like that. Those kinds of recommendations will be laid out for you often in detail. All the good ideas staff has will be offered up to you in written form generally. And then you may also have the next version, though, which I have it as approval of a resolution, but it can also be something along the lines of subject to the conditions listed in the staff report and the additional condition of fill in the blank. Here, you know, I was saying that, oh, well, let's approve what we're seeing in the paperwork and was in the packet, but we need to tweak something, subject to modifying section 2 to do something. And then you throw on the last clause is one of my personal favorites, approval with legal form by the city attorney. That's just me making sure that the English works and the punctuation's in the right place and that it does what you wanted it to do. It's not me rewriting what you're doing or changing the intent. It's me executing that intent with the legal paperwork and making sure it's not broken in some way that's going to frustrate what you were really trying to do. And then when you're tabling an item or taking no action, it is best form and practice to continue the item until the next meeting. Tabling has funky rules, and if you read the dark corners of the internet about parliamentary procedure, which I'm sure you're all going to do at your earliest opportunity, you will find that lots of people will say, well, actually, and push their glasses on their nose that, you know, tabling is not the right thing to do because you can only do that during the same meeting. And okay. So anyway, it's still just best practice when possible to at least announce the date of when you plan on taking action again. Sometimes that's absolutely necessary, but it just helps everybody understand what's going on and know that it's not just going to be continually, when do I have to find out about what happens here, particularly when you get to something that ends up being one of those contentious zoning cases or something.
And also for P and Z, I really prefer that when we do table or continue an item, we table to the next meeting, or if there is a further meeting that the applicant was requesting, but that we also state a purpose, because it's not our purpose as a commission to hold up a vote for any other reason unless there is something specific that we're tabling for.
All right, so we talked about it in brief earlier. I'll do another quick crash course on it. Again, look at the video. The Attorney General's website is a great resource. You're governed by TOMA, which means that we have to have posted agendas that are at least 3 business days prior to meeting day. Posting day, 3 empty business days, then meeting day. So you post them on Tuesday in order to have a Monday meeting. You can only discuss or act on items that are listed on the agenda. You have to give the public fair notice of what it is you're going to be deciding, or you can't make a decision on it. It doesn't necessarily have to have every bit of granular detail, but it's too vague and it could mean anything, well, you can expect it to not necessarily meet the standard. You're prohibited from deliberating on public business outside of the posted meetings in numbers greater than a quorum, or of a quorum or greater. There's criminal penalties if you knew that that was going to happen. Does that criminal penalty happen? Not very often. I can't necessarily say that I've got a ghost story to tell you about some P&Z commissioner who got locked up for 30 years on something like this. I can't say that that's happened. But the law does have criminal penalties, and theoretically the Attorney General of Texas can come after you for a violation of the Open Meetings Act or for the Public Information Act as well, if what you did was intentional or knowing. Accidental mistakes, well, you would at least have a good defense. Okay, but at the same time, I say don't take chances, try to stay well away from it, so you can't say, I didn't know that was going to be a walking quorum. If you never get started, you can't ever get to the point where you have to defend yourself like that. If actions are taken in violation of TOMA, they can be void ab initio. That is, if the Open Meetings Act was violated, you took a vote on something that wasn't on the agenda, that vote was void. It didn't mean anything. If the posted item was somehow otherwise defective, you could vote to approve something. And if the notice wasn't posted early enough, if the public notices weren't required or something like that, it might be void and the vote might count for nothing. And if deliberations occurred in between meetings, that could also throw things into question on whether or not they have to invalidate what the action taken was if there was action taken on the subject matter of the improper deliberation. What counts as a meeting? Quorum of the body. Public business or public policy discussed or considered, or between a quorum and one other person. So it's either 4 members of the body or between 4 members and a person, or a gathering conducted by the body with a quorum where the people come and ask questions and stuff. All right, so it's a deliberation that at least includes a quorum. A deliberation is a series of communications back and forth. Physical gathering of a quorum can be classified as a meeting and implicate TOMA. You should be notifying the city whenever you think 4 of you are going to be in the same place at the same time, because that's called a quorum. And if you're ever going to be at the same baseball game or something like that, Well, there are exceptions. It's allowed that the fact that you can all be at Fresh at the same time, and that's not necessarily going to be a problem. Okay, accidental contacts. There's a list in the statute. If you watch the meeting video, it will tell you all the stuff. That's why I'm trying to not bore you with all the exceptions to this stuff. But if all of you want to attend the same event, it's the football championship, and everybody in town's going to go, or it's one of the city, we post notice of quorums all the time for ceremonial events where we think the city count, ribbon cuttings and stuff like that. You can have notice of quorum. It doesn't mean you're doing business. It's a fairly simple matter for the city to just say, hey, there's an event on this date. There might be a quorum of P&Z or council or somebody there. Just tell us, and we can make sure that will get done. And then the red text is intended to be scary. Is the phone conversations, email chains, social media discussions relating to city or P&Z business can result in TOMA violations if a quorum participates. Like I said, I would tell everybody that the safest legal practice is to delete all your social media immediately. And hopefully forget all your passwords, forget you ever knew it, and start paying people around you to forget that it pretended never happened. However, no one takes that advice. I understand the 21st century is what it is, and it has become a near indispensable portion of our lives. So I must urge you to just be caution. Read, be intaker, take stuff in, try not to get involved in the comment wars, in the discussions. You will find that the members of the public are going to say things that are untrue or unfair about you or other people in the city. I just have to urge you to do your responding to that from inside the confines of a meeting. You can do a press release. You can set the record straight. You can ask for staff to address this particular item or to list something on an agenda so that you guys can discuss it in a safe forum. I'm happy to help you guys do that. Let's do it in a way that doesn't cause problems where we have people making accusations of quorums of the body, pre-deciding zoning cases on Facebook chats, on somebody's page of concerned citizens, or arguing about whether or not this building is ugly on a Pinterest comment reel, right? So walking quorums can occur if you have a member of the governing body who normally engages in one communication among a series outside of a meeting about matter within their jurisdiction, your official business, and they knew at the time that it was gonna involve a quorum, that the series of communications involved would involve a quorum, that when it involved a quorum would be a problem. All right, that's really what it amounts to, is if you knew that you were gonna be, I'll talk to just one member and one other member, and then they'll talk to two others, and eventually we'll get it all done, but we won't have any of us talking to a quorum at a time. Ha, we beat the system. Nope, they knew about that when they started it up. Walking quorums are still a problem. So, best practices. Restrict official business communications with each other to TOMA notice meetings. Never reply all to any email. I almost always encourage every city staff member to send emails to you when they're sending them to a body, to have you all listed as BCCs, or blind courtesy copies, on an email to themselves or to another staff member, so that way, even if somebody does blunder into the reply all button, it doesn't turn into an open meetings violation when I says, what the hell is this? I'm voting it down. This is horrible. Okay, well, we don't want that email to go to everybody. Ask questions to staff, not each other. That was something that we brought up earlier, but that's the best way to do it. And you can invite information from the public. You can solicit comments. I encourage you to do that, but you just need to try to keep your thoughts reserved in terms of what you're thinking or what you're planning on doing until you're in this room and you can talk to each other about it. Public Information Act. This one will be also really quick. All the records relating to the business of the P&Z belong to the city. So that applies to all devices everywhere, entire planet, including your emails and social media posts, even in your private accounts. Handwritten notes, if you write on that agenda, you have made with your pen a new public record that's different than all the other agendas, because that one has your notes on it. So if your notes relate to city business, you are creating unique public records that need to be accounted for or could be summoned from your possession by a public information request. Social media messages sent or received, whether they're public or private, those would count as public information. You are a temporary custodian. This is a new classification that came out about 5-6 years ago. The concept had been there before, they formalized it. Temporary custodianship is meaning that you have a public document and the city doesn't. You are temporarily a custodian of a government record. How do you get rid of that? That's, give it to the city, all right? Give it to us. As soon as we get a copy, you can stop worrying about it, okay? Because you can keep your copy, that's not necessarily the problem. The point is that once we have it in our files, it's archived, you're off the hook for being a temporary custodian. So easiest method to get rid of something, or at least to stop being a temporary custodian of that item, is to just forward it to a city email account, any city email account. It could be your city email account. All right, now it might be more useful if you want to do anything about the information you've been given to send it to somebody other than yourself. But even just sending it to yourself preserves it in our servers so that we'd be able to have it and IT can find it. If we have a public information request, we don't need to go asking you to cough it back up. So we will retain the record for the required period under Texas law and then hopefully delete it unless the city has a good reason to keep it for longer than that. So the temporary custodianship status is important when we get, like I was mentioning, public information requests, because somebody will say, I want all documents relating to Lafayette Crossing. I have to process that. And people will send in a request that reads almost exactly like that, without even knowing what they're asking for. And in that case, it would be something on the order of 30,000 plus emails. And I'm not exaggerating. It would be on that order, and the number of 100-page plus attachments to each of those emails would boggle the mind. But when we get one of those big ones that's a giant fishing net that somebody's throwing, we have to have IT do server-side searches to pull together the host of stuff from all of our city email inboxes and stuff like that, which is a daunting enough task of itself. But we also have to poll elected officials and appointed officials to say, if you've got anything that we don't got that's on this topic, you need to cough it up now, because we had a PIR. Somebody asked about this development, and they said they wanted all documents. Now, we do what we can to try to narrow requests and to reduce the number of times we have to do this, but periodically you're going to get an email from the city secretary's office saying, I need you to send me anything you've got in your private accounts about this topic. And they'll hopefully give you keyword searches ideally, or they'll tell you to do this. And if you have anything on your personal devices, you should be, sending us screenshots or giving us some other means of getting that communication. So one of the best practices is, like I said, in order to stop being a temporary custodian, is that people are going to reach out to you sometimes. They're going to know you're a member of the P&Z. They're going to say, I know you're plugged into what's going on in the community. I have this concern about business, about something that's going to come before you or is coming before the city council. I want to talk to you about that. They reach out to you via social media or regular your private email account or something like that. That's not a problem. Just transfer the conversation to a city email account if you can, right? And that's where it is the best thing to do, or say, at the very least, when the conversation is over, forward a copy of it afterward to city staff so that they can be preserved in the city records. All right, so finally, we're getting to the last bit, which kind of dovetails on the last two in terms of ethical considerations. You need to consider the applicant in each agenda item to make sure that you are identifying potential or perceived conflicts of interest. There's only certain relationships that actually result in a statutory conflict of interest, and that's what I mean by potential, or that's the real major conflict of interest. But there's perceived ones as well, where it just kind of feels weird or it looks like that you're going to have bias or impartiality and problems. And you should at least always consider those. And if it's something that makes you really wonder, or you think that the public is going to have significant concerns about, you may want to ask staff questions about that. So ministerial duties may require you to approve documents for projects that you don't personally favor, that you don't like it. You can say, I don't like this idea, I think this is a bad plan, I don't want another car dealership, I don't think we need more fast food, and that's what this project is for, and I don't want to do it, but it's my job to approve it. So I ask you to always be mindful of your oath of office, though. In those times of difficult decision-making, you take an oath to uphold the laws of the state, which includes service to the city council and obedience to its ordinances and trying to execute on its comprehensive plan and stuff like that. So that's why you're being asked to do what you do, and it's often a thankless job. I will thank you for doing it because the city couldn't function without your assistance, but the public will often only have criticism, and I thank you for being willing to endure it. The Fake Code of Ethics is applicable to you guys, so you should obviously familiarize yourself with that. If you have a substantial interest, we'll talk about that definition quickly in a second. You're not supposed to be participating in those decisions. You're not supposed to represent any private parties directly to advocate for them before the city council, so they should have to find other spokespeople. You certainly can't accept gifts, AKA bribes, for these things, in exchange for your votes. And obviously disclosing confidential information such as legal advice given in closed settings, confidential memos that might be distributed for your review via email and that sort of thing. Substantial interest, 10% or more of the voting stock or shares, 10% ownership stake in a business or something like that. That's a fairly basic, simple rule. And then there's kind of the ancillary rule where if more than 10% of your income comes from that, if your employer was, for example, making an application for the board, you should probably recuse yourself from the guy who's writing your paycheck if it's more than 10% of your check. That's kind of the way the rule goes on that. That's item 3 on this list. But it's basically 10% ownership or 10% more of your income. And then a stake in real property is addressed there at the bottom, where it's a lot more broad. It's almost any ownership stake in the real property should make you say, this is entirely radioactive. I should not have anything to do with this if it involves 1 inch of dirt that you have an ownership stake in. There will only be very rare exceptions to that, and I would encourage you to seek some legal advice on that before continuing to act if you own any of the land that's covered by an application before you. Now, that doesn't mean you can't zone your own neighborhood. That's a little different. It's not your application, okay? So, yeah, there could be instances where it'd be a little bit weird if you were to act on a certain zoning case and it's literally your next door neighbor's lot or something like that. There's plenty of circumstances there where I'd say that, you know what, there may not be an actual conflict there, but there's enough of a weird one that you probably want to stay away from that.
David?
That's always something to consider.
So our standard practice is that if a planning and zoning commissioner falls within the 200-foot notice area, it's generally best practice to recuse yourself.
Well, I cover that in this very next slide
go.
where you've actually got that. For the next door neighbor was a bad example then that I just used to inspire that comment, because you're already prohibited from doing it in the 200-foot zone. And that would always be, absolutely, you're right, the best practice. But honestly, I've had it and I've seen it in other cities where somebody says, well, that's your subdivision. That's your neighborhood. Of course you're going to favor that. That's your HOA. Okay. Well, there's only so many HOAs, right? And we need 7 of y'all to fill seats, okay? And we want them to be from diverse areas of town. We don't want everybody to be in one, because we could do that. You could pack it, right? You could have all of you from the same subdivision and then say, well, you can do everything impartially on every other subdivision but your own. But then, of course, nothing happens in that one until we get rid of all y'all and replace y'all with a different subdivision. That wouldn't make any sense. So they're going to come up from time to time where it might be a little bit too close to home. We can help you figure out whether or not you have an actual conflict or just a perceived one. Sometimes there'll be circumstances where we might say, well, we're going to have trouble making quorum if you can't attend that meeting or if you're not able to participate in that item. So there may be times where we'd say that, we know you're uncomfortable, but it's not a real conflict, so we're going to say you're allowed to participate.
So on the lines of that, let's say I received the agenda, like you said, 3 days prior to the meeting, right? And I see that my division is on there. So who do I contact first if I feel like it might be a contract, a conflict of interest? Like I kind of want to know the steps to ensure
the
that
first
on
person,
day-
the first person to notify is Ryan. Every time on almost everything that has to do with every question, I'm going to say go to Ryan first. Now, like I said, it's not just that you can't act on something that's in your subdivision. Like I said, the city's only so big and the neighborhoods can be, of varying sizes. So that shouldn't be the trigger necessarily. It should be something that really jumps out on this is really close to home. I have a special connection. Then I know this person. They're my sister-in-law, that sort of stuff. We'll get to those relationships there in a minute. But it shouldn't be just as simple as, well, hey, wait a minute, they're in the same subdivision as I am. But when you have the questions, bring them to Ryan first, and he'll jump on it immediately, I assure you. So when you figure it out, if you have a substantial interest, you must disclose and abstain. You have to file an affidavit about that in particular, and abstain from participation. And then this is also the same thing kind of echoed in the Local Government Code, Chapter 171. Before any vote or decision is had, you have to disclose it if you count as a local public official, and have essentially the same kind of parameters, but also provide another spooky penalty for a violation of up to a year in jail. All right, so here's the quick chart. There's plenty of them out there. There's 2 degrees of affiliation, consanguinity or affinity, as they would say, blood or marriage. If they're within 2 steps, they are too closely related to you to be able to act on their matter. I'm not going to spend too much time dwelling on the various scenarios. That's the picture. There's plenty of them out there. You can look for the charts. The state of Texas has a different one that's a flow chart with boxes and stuff like that, that also has all the cousins and stuff like that if you ever really wanted to figure out how third cousin twice removed works. I already covered that, I think. So,
I have a question.
Oh, sure.
So we say we get the agenda, we look at the documentation, at that time, we don't see a conflict of interest. As we progress during discussions, the applicant brings up a company name, somebody you know by chance. Since it wasn't addressed before, we didn't know that this was going to become a conflict of interest. At that time, do I make a motion to say I must recuse myself because I believe this is a conflict of interest? Or what is the proper procedure for that?
So I think that you're right to think that there is certainly a need to kind of try to hit the pause button for a moment. And, I'd say, excuse me, Mr. Chair, I think we need to address something before we continue, might be the way that I would introduce the item,
Okay.
to try to stop whatever the discussion was happening, because that might have been midstream and 3 slides into their presentation where you see a logo pop up and that's your husband's company or something like that. And you're like, whoa, okay, wait a minute, is this a problem or not? By and large, though, it's the applicant who's the one who stands to directly benefit from the action you take and the vote you take. So you can have relationships to other people related to them, that if the applicant is a land developer and your husband worked for a construction company that pours concrete and would potentially get business for this new development in town, that wouldn't necessarily make you unable to vote on the zoning matters, just even if your husband's company had a pre-existing contract with the applicant. That doesn't necessarily get you there, because you don't have an interest in the company who's got the thing getting the vote. And if they don't get their way, that contract goes away. It can be a difficult and awkward situation to have a relationship that looks really strong like that, or at least that's a couple dots away. But The law is fairly specific in terms of what ownership counts and what counts as a financial interest that you have to be concerned about. And it's a direct relationship to what your assets are, not even your spouse's to a large degree. It's about what your income and what your ownership is and the applicant. So, obviously I can assist with these assessments, as questions come up, when they come up. One of the things that makes it impossible for me to know in advance of a meeting, though, and warn you as individuals, is that I do not have access to, and I don't want access to, any of your information on your personal affairs or your finances and stuff like that. So we don't know until y'all tell us, okay? That's the thing, is that we're not auditing your finances and stuff like that and, knowing what all your relationships are. So just my few parting thoughts, though, are, staff works really, really hard to help you guys. So I always ask all the appointed officials to try to make sure that they're well prepared for meetings to the extent you can. I know that it's always frustrating when staff sometimes get stuff to you late, but that's only because the work was harder than they thought it was going to be, and stuff came up and fires broke out. And so if you find yourself in that situation, please see if you can try to spare the time to read the packet anyway. But particularly when it's posted on time, you've got at least 3 full business days guaranteed by Texas law to find the time to examine the agenda packet in detail. Now, it's not like you have to memorize it or commit it to memory, but at least know what the items are and what kind of actions you're going to be asked to perform. And if you don't understand what's going on or what this item means, ask the question. Send the email to Ryan. He'll explain, okay, this is what it is. If you want more details about the project or just want to know if there's any more detail about the project because you're just curious, go ahead and ask. All right, we may or may not know the answers, but we'd like to give them to you. And study the packet so you know those questions, because it's always frustrating for applicants and your fellow board members alike when somebody is unprepared and has to ask very, very basic questions from the podium to wrap their head around what vote they're going to have to take. You can visit subject sites in person if you're unfamiliar with them. That's often a good step to do to get a better real feel for how big an area is or the topography or something like that, but it's not required. But you can look at locations online. Satellite images and Google Street View goes a long way in letting you help wrap your heads around what's going on. You should avoid receiving information from the public outside of a hearing when you can, all right? Avoid transmitting information to, that's what it should say. Oh, I'll have to change that one. That slide's broken. I'm sorry about that. Ask questions to staff extensively. That's what I say over and over again. So yeah, and you should limit your discussions of P&Z action items. If it's something that's going to be on an agenda, wait until the meeting to talk about it. People see it on the agenda. People might want to talk to you about it, but you don't want to get into pre-meeting debates about the stuff that's going to come before you on social media or a grocery store wine bar. That could be a hazardous environment, okay? And so if somebody accosts you there and wants to talk about a zoning case, you can listen, but then should politely decline to respond and certainly not argue with them or start telling them how you plan on voting, because you don't know who they're going to talk to next and who might be in the frozen foods aisle. So that is the end of what I had prepared. So I would be happy to take questions or sit down.
Thank you very much, Mr. Overcash. We appreciate that. That was a great presentation. I just wanted to add a couple of things. One, we really are a tool for council, for staff to get feedback from us on what we think about an item that's being presented to us. Council might be looking at these meetings to see how we debate them. I always say the vote that the commission takes is almost not as important as the discussion that we have. So please try to elaborate on what your reasoning is. But also, if you want to take a vote and not state what your reason is, it's not your obligation to do so. You can take a vote without giving a reason. But always remember, we're a tool for council. And the items that you guys are talking about as far as getting into a conflict of interest, it's going to be very, very few and far between. Have no worry about it. You know, we'll talk to staff beforehand. If it happens in the middle of a meeting, we'll address it. It's not going to be an issue for anybody. And I think in 10 years of doing this, I've never gone into executive session as a P&Z member, so don't have to worry about that one either, probably.
It's extraordinarily rare. I can think of some circumstances where it could arise, for example, if there's a lawsuit, a litigation hold, if there's some sensitive legal concern associated that's not necessarily the action item is going to blow up. It's that there's weirdness going on surrounding the applicant or surrounding something else, or somebody's suing the applicant already, and so y'all just need to, sometimes it'll be for just a advisory from my office to say, hey, watch what you say and try to just stick to the business and don't get drawn offside by anything weird that might happen on something like that. I did want to piggyback on one comment you had. I do echo your statement that it is certainly not a requirement as you're casting votes in a roll call fashion or otherwise to state the rationale or the basis for your vote as you're casting it or anything like that. But on that one specific item, when it comes to plat approvals or plat disapprovals and approvals with conditions, in those circumstances, you do have to explain your votes. But you explain them as a body, not as an individual as you're casting them. You have to explain the sausage afterward. It's kind of the way it is, not necessarily every ingredient that went into it, because one of the weird things about that particular requirement is that you're a body that makes collective decisions, and it's going to be when you're down to 6, it's going to be 4-2 that makes the decision on whether or not something might be approved with conditions or disapproved. Let's just say that. Let's say it's disapproved. If it's disapproved and you have to give your reasons for disapproval, well, those 4 votes for disapproval could theoretically have been for 4 people with 4 different reasons that all said, I don't like it for this reason, I don't like it for this reason, I don't like it for that. And they might not all be in common. Well, we're going to have to figure out how to articulate that rationale for decision or disapproval to the applicant so after the meeting happens. So ideally, there will be a consensus between you between a majority on why you vote a certain, or what the conditions should be. And that might be one of the trickier things you'll have to do from time to time, is going to be, you want to approve something with conditions, and you're good with the staff conditions, but you've got 1 or 2 others in mind, and you can't come to an agreement on that, where it's hard to form a majority on, we got 5 conditions that we all agree on, but we're split minds on 6, or on number 6 or number 7. That's where sometimes I think your hardest decision making is going to come in, is just figuring out how to resolve that and say, okay, well, do we include this extra condition even though that some of us don't think it's necessary, or do they just kind of lose out and say, well, your other idea has to be left on the cutting room floor because it doesn't get enough momentum behind it. And that's the way it'll go sometimes. And I hope that everybody will be adults about it when it's their idea that gets left behind sometimes.
Well, thank you again, sir. And commissioners, if you come up with any other questions, if this discussion has generated any other questions for you, and also in the future, if you have any questions that you think are legal in nature, I ask that you please send them to Mr. Wells. He will filter those out. Many of those he'll be able to answer on his own. He may send them up to legal after that, but we need to go through Mr. Wells first.
I did have an additional question regarding, you were talking about documentation. I know we receive the agenda, we look over the documentation, and we write notes on our devices and on paper. Is there a retention period regarding this information? And how should it be secured at home? I'm assuming it should be secured in a locked area, but I don't know what the rules are for this information.
So by and large, the handwritten notes you would write on an agenda or something here for you are not necessarily going to be related to official business in any legally coherent way, in the sense that you're allowed to take notes for your own memory retention purposes, all right, for your own following along. You can doodle, on here. You can write down, you can make your grocery list, all right? The grocery list is not city business, right? So putting that on your agenda does not turn it into a new unique city record, because that part of it isn't city related. So taking notes during, to follow along and help keep track of somebody's conversation is not necessarily going to be something you would have to preserve forever at your house. when there are notes to remind yourself of things and that sort of things, they have administrative value is what you would call it. Like the Post-it note you write to remind yourself to make a calendar entry. You have the Post-it note that has administrative value until you make the calendar entry, then you can throw the Post-it note away. All right, because you don't need that anymore. The calendar entry took its place. So sometimes you're making notes in order to remind you to send an email. This is what I need to say. I need to do something else. Now, there will be times if people are passing notes on the dais that you're going to see public information requests. People can see that online and stuff like that, and you will get PIR saying, I want to see those notes. Okay? By and large, you know, you can certainly write your own notes on things, but it's best practice to transfer them to some other document or some other form that you can retain and keep in a more coherent way. You know, type your notes into an email, send it to yourself. Then you don't have to worry about the piece of paper anymore. If you send that to a city email account, now you don't have to worry about being a temporary custodian.
Yeah, and I would just add, if you are concerned about that, if you have any thoughts, you know, is this or is this not, take a picture of it, email it to yourself, you're going to be covered. And then if you have any other questions about email, if you get something on your personal email, I would recommend that we hold those for right now because we can kind of go into a rabbit hole on those. So let's save that for Director Wells, and he can either handle the question or he can get it to the city secretary, who can also is also very good at records retention information. Okay. Anything else? Okay. All right. Moving on to item 4A, consent agenda. Discuss, consider, and take any necessary action regarding approval of minutes of the Planning and Zoning Commission meeting held July 16th, 2026. Any questions or a motion, please?
Motion to approve the consent agenda.
Thank you.
Second.
All right, we have a motion to approve the consent agenda by Commissioner Clayton and a second by Commissioner Horton. Any question, discussion? If not, can we get a vote, please? I can't tell if mine worked. All right, there we go, and that passes unanimously. All right, as discussed earlier, item 5A, the zoning change request is being moved to the September 17th meeting, and that will be renoticed at that time. Item 5B is an item that I requested be added to the agenda. This is to discuss and consider and take any necessary action regarding the potential implementation of a pre-session briefing at the start of each scheduled Planning and Zoning Commission meeting to provide a high-level overview of agenda items and relevant ordinance, zoning, education for commissioners and staff. To kind of go into a little bit more detail, it is a publicly noticed meeting that we could have that would start at 5:30, and this is to have general discussion about the agenda items that are before us. We can use that as an opportunity to ask general questions if we wanted minor clarifications on things. We could also use that as an opportunity, since we do have some new commission members, to discuss zoning changes, ordinances, SUPs, variances, how we're supposed to be discussing that item, which can all be very, very important things, especially as we're new and we don't know how to do that yet. So I think it would be a great opportunity for all of us, especially because we only meet once a month. It's going to be hard for us to get into that rhythm when we're not having a lot of meetings without a lot of agenda items, so I think it'll be very helpful. But I wanted to get feedback from my fellow commissioners if that would be something that you're willing to do. I also like that we started at 5:30 because it has to finish at 5:50 or 5:55. It's not going to go on. It won't drag out. It'll be limited, but it is a good opportunity for us to have some general discussion before the official meeting. Does anyone have any questions on that? Does anyone disagree, agree with it? How do you all feel about that?
I agree. And prevent.
Yeah, turn on your microphone, please. Sorry.
I got to get used to it. Yes, I agree with it wholeheartedly
Thank you.
with that.
Commissioner Clayton? No, okay. No issues or no to it?
No, no issues with it.
Okay. Commissioner Allen?
I'm good with it. I think it's a good idea.
Commissioner Horton?
No issues.
All right. And Commissioner Garcia?
I think it's an excellent idea.
Okay. I would just ask, I don't know if we would take any, do we have to take a vote on this, or would the next step be for staff to make sure that we don't have any issues with the
Yeah,
setup of this?
I would consult with our city secretary just to make sure that we have the correct structure to that. And again, it would be a publicly noticed, in the form of being on the agenda. We wouldn't have to like mail out a notice or anything, but it would just be a standard item on the agenda as a planning and zoning workshop or something like that. I believe, Chair Alvarado, you wanted to hold those in the conference room. I think that would be okay as long as it's publicly noticed, open to the public and recorded to some degree.
To some degree, yeah.
I think we have the hardware that we could record it in some fashion. It may not be live streamed, but at least it could be recorded. Maybe we'd figure out the live stream, but we'd figure that out before the September meeting.
Okay, perfect. Thank you very much. With us not having to take action on that, that takes us to item number 6, Director of Planning and Development Services, reports, announcements, updates, sir.
All right, great. So let's have a couple of things tonight. First off, next week is a very big week for our department and for the community, as we have been working on our comprehensive plan update starting in June. Next week is our 3-day design workshop and open house event. That is going to be held at First Faith Church over on 813 West Holiday. The whole agenda is on the forwardfaith.com website, but a couple of key engagements is the most important one is the public open house. That's going to be on Thursday, August 27th from 6 to 8 p.m. at that location. They've graciously offered to host us for the whole 3-day engagement, which is great. It kind of gets people away from City Hall, out in the community a little bit more. And so that's where we're going to have a bunch of different stations with information. We've already gotten a lot of feedback from the community. Now we're going to start chewing on some different ideas. And so we want as many people in the community to come out, give us their time, give us their input. It's not going to be just the same stuff that we've already been talking about. We're kind of evolving the conversation as the project moves on. So again, the public open house, August 27th from 6 to 8 p.m. Also, earlier in that 3-day engagement, there's going to be a CPAC meeting. Those who are on the CPAC have received some notices of that. There's going to be a working group meeting, which has already also been sent reminders. We have 4 focus groups that we'll be talking with during that period of time, including downtown business owners, HOAs, school district, and other PTO type groups. So we're gonna have all those, and economic development discussion as well. So those focus groups are gonna be engaged during that period of time. So that 3 days, we're gonna be very busy, very working and talking with a lot of different people, and I hope that you'll be able to make time to attend that open house. Also related to the comp plan update, as you know, we've had some pop-up events. We were at the Polynesian Party in the Plaza a couple of weeks ago. Just last night, we had our senior planner, Catherine, was at Beer talking with a group of community members and business owners about things related to the comprehensive plan, just the city in general. Our next pop-up is going to be at Pause for Wine over on 1138 and 66. The address is 7551 State Highway 66. That's going to be from 6 to 8 p.m. on Thursday, September 3rd. I'll be hosting that one, and invite anybody in the community, members of the P&Z or otherwise, to attend that event, just to share your thoughts. Get into a deeper conversation than just kind of a pass by. This is what I like. This is what I don't like. And then finally, one more reminder that on October 14th through 16th, the Texas chapter of the American Planning Association is hosting its conference in Irving at the Convention Center in Las Colinas. We have a space for one more member of the P&Z if you want to attend that. We can either do a 3-day attendance. I know, Amy, you said you're attending for the full event, right? Yes. If you only have 1 day available, there's like a 1-day registration we can do too. Just reach out to me individually if you are interested and available, and we'll be happy to set you up. Again, we'll cover all those costs. We just want opportunities for our Planning and Zoning Commission, beyond even tonight's presentation, just to be educated, to understand planning theory, to understand best practices in the area. And so this is a great way to do it. So just reach out to me if you have questions, and that is it for me.
Well, thank you very much, sir. And again, thank you to Mr. Overcash for everything tonight. It was wonderful. With that, we're ready for adjournment. Can we get a motion to adjourn?
Motion that we adjourn.
Second.
We have a motion, we have a second. Can we get a vote, please? All right. It is, what time is it? 7:39, and this meeting is adjourned. Thank you, everyone. It was lighter.